So you've been in a car accident and you're going through the claim and settlement process. And you might be adamant that you want your day in court. But that's pretty unlikely to happen most of the time. There are a couple reasons why car accident cases rarely go to court and often end in a settlement. First, let's talk about what is trial and do you really want to go there? If the insurance company is not offering you reasonable compensation for your case, that's when you may want to file suit or what's considered going into litigation, which leads to trial. A lot of times clients don't like this, and one of the reasons is because most injury lawyers' fee, the attorney fee, does increase once a case goes into litigation. The standard fee, which is my office's fee, for instance, is 1/3 pre-litigation, so 33.3333%, or 40% if the case does go into litigation, because a lot more work is involved and a lot more overall involved once the case goes into litigation. And for any clients that are worried about, oh, that's a large attorney fee, I want you to consider that 60% of a watermelon is a lot more than 100% of a grape. Now, a good ethical lawyer will only file suit when it is necessary and in the client's best interest. We're always going to try to get the case settled pre-suit. I think the main reason that car accident cases rarely go to trial is because experienced injury lawyers know how to properly work up the case. Every case has a value range. However, no lawyer can tell you exactly what your case is worth. We can sometimes give a range on what we believe based on our skills and experience your case is worth. Also, and if you've hired a skilled injury lawyer, they know how to what we call work the case up. That means we know how to look for the best evidence that's going to paint a picture of your incident, your collision, your medical treatment, your injuries in the light that is most favorable to you and your case. So by the time we get to the settlement negotiation stage, the insurance company has no option but to act reasonably and offer you fair compensation for your case. Maximum compensation, maximum value. Now, contested liability cases, those are more likely to go into litigation. Contested liability means that there is some argument on who is at fault for the collision. So if driver A gets hit by driver B, they're trying to say that driver A was at fault or has some fault in causing the collision. And we have to fight that. Now, if you're dealing with a regular rear end collision where driver A is driving and driver B runs into the back of them, most of the time, that's not going to be contested liability because you're never really supposed to run into someone, especially hitting them in the rear. There are some cases where there could be some liability on driver A, but we're not going to talk about that right now. So if it is a contested liability case, it's more likely that you're going to file suit and litigation is going to be necessary. But an experienced injury lawyer will know when to fight that battle, when to file that lawsuit. In my firm, it's a goal to try to resolve each client's case pre-suit without filing a lawsuit. One, that gets the case resolved quicker for the client and the money in their hands faster. Also, it keeps the attorney fees down lower to the 1/3, 33.33%. Much as I love money, I don't ever want to make money at the expense of a client when I could have gotten it for them pre-suit and not had to raise the attorney's fee up to 40%. Also, a lot of clients prefer not to go into litigation because once you file that lawsuit, things get very personal. They're going to want to know about your prior medical history. They're going to want to know if you've ever been arrested, charged with any crimes. They're going to want to know how many significant others you had in high school. They're going to ask you a bunch of questions. It might not get that personal, but you get the idea. With all that being said, we're still not going to settle the case pre-suit unless the insurance company is offering the right amount within that range. We got to get you full compensation. But if we can settle your case pre-suit, keep the attorney's fees lower, help maintain and protect your privacy, and get you the right amount of cash in your hand, why wouldn't we? And when I say get the money in your hand, sooner, that's because in my main state of practice, South Carolina, I practice in South Carolina and Georgia primarily, but I'm based out of South Carolina. When you file suit, your case is not going to go into the trial roster until 1 year after the date you file suit. That doesn't mean that the case won't settle during that time period. But if you want your day in court, you want to go to trial, just know it's likely, not at all, going to happen until at least 1 year after the date that you filed suit. Could be longer too. For example, I had a client that was in a very bad car accident in December of 2019. We still haven't gone to trial. It's been on the coming up on the trial roster and keep getting pushed back. But 2019, again, that lawsuit was not filed until towards the end of 2021. But 2021, we've gone through 2022, and now we're coming up on 2 years since that lawsuit was filed. Things in the legal system don't move as fast as you think they would. So if you're looking to speak with an experienced injury lawyer and you want to get an idea of how much your case might be worth, a range of value, please feel free to give me a call. Let's talk about it, give you more information about your case and see if it's something that I can possibly help you out with.